this is historic because there is no other case in which parents in the United States have been charged with a crime as a result of a school shooting that occurred at the hands of their child. What do you think of this case and the fact the parents are charged?
You know, I don't know how I feel about this thing. It is a first of its kind. It's pretty remarkable. I understand that we as a culture are saying we've had enough and we have to do something to stop this. And we're trying to look for the causes of these types of tragedies. And one of the places that people naturally look is the parents and go, why didn't they do more? Why didn't they take action? But, you know, it was brought up earlier that this trial is going to really become about, are they bad people? Were they having trouble in their marriage? Were they neglectful of their son? Were they paying attention to their horse's health more than they were paying attention to their son's health? All of which we can judge them and say, you know, in hindsight, they should have done more. But does that make them criminally negligent? Does that mean that they should be held criminally responsible for what took place that day? And I'm struggling with that question because, you know, who knows if they could have taken steps to prevent this? That's really going to become the question. Had they gotten more help for him, would this have stopped this tragedy? Certainly, a big question is going to be the access that he had to that weapon. Is there more that could have been done to prevent him to have access to that weapon? But he's an independent person who made choices and took actions all on his own. And is it the parents' responsibility to prevent any kind of tragedy like this? Not taking away from the loss of those 4 children and the tragedy of all of this, but is it right for us as a society and as prosecutors to point fingers at parents and say, you should have done more? And not only should you have done more, but because you didn't, we're holding you criminally responsible. That's where I struggle. And
I do think that's the very question. What a great way to articulate that, because that's the very question that I think is being faced by this trial. And just for awareness purposes, each of those involuntary manslaughter charges carries a potential of up to 15 years sentence and a $7,500 fine. But for 4 counts, concurrent or consecutive makes the difference. But they could be looking at a lot of time if convicted. Let's move and talk about one other thing from the hearing that was noticed yesterday. And you may have seen in the video that we showed from our affiliate, they were shackled. The mother and the father were shackled. And we know there's been a motion to say, and the motion was filed by the prosecution to say, these 2 defendants, both on virtual hearings as well as in court, have been seen mouthing what appears to be, I love you, blowing kisses to one another. Do you think, Randy, that's the reason why they were shackled? Because you don't always see defendants shackled in a probable cause hearing.
I mean, I don't think there's a legitimate reason to say you can't mouth "I love you" to your spouse and to your co-defendant. But I think the real reason is effect, right? We all know that you're supposed to think of people as innocent until proven guilty. But when a jury walks into a room and sees people handcuffed, shackled, in prison gear, they automatically jump to conclusions. That's why defense lawyers fight all the time. That's why in the Ahmaud Arbery case, you saw even after the guilty verdicts, they fought to let them come in suits, in civilian clothing, because they appear more like normal, everyday non-felons. And so the prosecution is happy anytime they can have a defendant sitting in shackles in prison garb. It helps their case. It helps the mindset of the jury.
And Josh, flesh out a little bit the reasons why a defendant may choose to actually have a preliminary hearing or a probable cause hearing, because we know that standard of proof is much lower, and we know frequently defendants waive that hearing. They don't require the hearing. In this case, they wanted the hearing. Why might that be?
Yeah, each state handles this a little bit differently, but it's required that you surpass, like you said, that hurdle of probable cause in order to hold somebody to answer for trial. In some states, they waive it. Here in California, it's very common that everybody goes through their preliminary hearing, and the largest reason for it is it gives the defense a preview of what might come, of what the prosecution's case is. Now, it's not presented in front of a jury. It's only in front of a judge, and as you pointed out, the standard of proof is lower. We're only talking about probable cause rather than beyond a reasonable doubt. But still, the prosecution for the first time has to kind of show their hand, as it were. They have to present testimony. They have to present documents. They have to present evidence, and it gives the defense a preview of that. The other thing it does is it holds this testimony, it captures it in time. In other words, a person who testifies at prelim, they're now bound to what they said at prelim, because if they say something different at trial, a good defense attorney is going to cross-examine on that, on those discrepancies in their testimony. So it's always beneficial for a defendant to kind of, as it were, get that preview and then have that testimony locked in.
All right.